and welcome to the channel. I'm Maddie, and for those of you who don't know me, I am an attorney, a former college athlete, and I also chaired the NCAA Division I Student Athlete Advisory Committee while I was in school. Now in this episode, we're going to discuss Title IX. And this is a very important topic and one that is very misunderstood and often used as an excuse by schools for why they do things like cut programs, for instance. So we're going to address in this episode what Title IX actually is, how it applies to athletics, and talk about what, in effect, Title IX really does, and why some of the excuses made by schools just simply are not true. So, to start with, Title IX is a federal law that states no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. And this was part of the Education Amendments of 1972 to the 1964 Civil Rights Act. It's important to note that Title IX is not gender specific, so even though in 1972, when this was passed, it was geared towards creating more opportunities, more equal opportunities for women who were so heavily discriminated against at the time. This applies equally to men. So if a man is being discriminated against on the basis of sex at an educational institution, Title IX would come in. Title IX covers all public school districts and virtually all colleges and universities because they offer education programs, and most also participate in federal assistance programs. Those that don't, Title IX would not apply to. And then there are some carve-outs for religious institutions, but we're not going to go into that. The section of Title IX that applies to athletics states, no person shall, on the basis of sex, be excluded from participation in, be denied the benefits of, be treated differently from another person, or otherwise be discriminated against in any interscholastic, intercollegiate, club, or intramural athletics offered by a recipient, and no recipient shall provide any such athletics separately on such basis. Now we know that this applies to high school athletics just as much as it applies to college athletics. What a lot of people don't know is that in 1972, the NCAA governed only men's sports and championships. They specifically banned women from participation in NCAA events and championships. So instead, women's sports were governed by the AIAW, the Association for Intercollegiate Athletics for Women. And by 1978, though, women's sports had gained popularity and there was a lot of participation. So the NCAA started sort of trying to corral women to participate in its events. So by 1981, the AIAW sued the NCAA under antitrust. They lost, and sort of the rest is history. But that was what was going on behind the scenes. The NCAA was at no time championing women, and it cannot be claimed that they were. The NCAA fought Title IX every step of the way. And when it was initially passed in 1972, a senator from Texas introduced a bill that would have exempted college athletics from the application of Title IX entirely. When that didn't pass, he introduced a bill that would have exempted just revenue sports from application of Title IX. That also didn't pass. Do you notice a pattern here? Because these things play out now as well. But what ultimately did pass was known as the Javits Amendment in 1974. And the amendment stated that the Title IX regulations must include reasonable provisions considering the nature of particular sports. And essentially what that means is that universities do not have to delegate funds equally between men's and women's sports. I want to say that again. Schools are not required to spend the same amount on men and women, male and female athletes, and are also not required to spend the same amount on male and female athletes within the same sport. And moving on to the rule about athletic scholarships, there is another perception that somehow they have to be the same. That's not actually true. The rule is, to the extent that a recipient awards athletic scholarships or grants an aid, it must provide reasonable opportunities, there's that word again, reasonable, for such awards for members of each sex in proportion to the number of students of each sex participating in interscholastic or intercollegiate athletics. So again, Title IX does not require schools to provide the same number of scholarships to men and women, or even the same amount. The requirement is that the spending on scholarships between men and women has to be substantially proportionate to their participation in athletics. The Office of Civil Rights has specifically provided guidance about whether Title IX requires cutting or capping of athletics teams in order to achieve compliance with Title IX. And what they say specifically is nothing in Title IX requires the cutting or capping of teams in order to demonstrate Title IX compliance. In fact, as stated in the 2003 further clarification, the elimination of teams is a disfavored practice because it is contrary to the spirit of Title IX. When the results of an investigation show non-compliance, OCR's policy in negotiating compliance agreements is to seek remedies that do not involve the elimination of teams. I feel like I could stop this video here because that in itself answers the question of whether Title IX is responsible for schools having to cut teams. The OCR would never make a school do that, according to them. So that is an institutional decision that they don't want to reallocate funds in such a way that they can keep teams. And mostly what that means is that they're giving bonuses to football and basketball coaches and paying them disproportionate amounts in salary compared to all other coaches, and the budgets for their teams are also grossly disproportionate, and we're going to get into that too. But Title IX in no way requires schools to cut teams in order to be in compliance. Title IX does allow schools to have separate men's and women's teams, and it also allows schools to offer a sport to one sex and not the other. With the caveat being that if that is the case, they're supposed to allow the unrepresented sex to try out for the team. But wait, not so fast, because there is a contact sport exemption. And what that says is that where a recipient operates or sponsors a team in a particular sport for members of one sex, but operates or sponsors no such team for members of the other sex, and athletic opportunities for members of that sex have previously been limited, members of the excluded sex must be allowed to try out for the team offered unless the sport involved is a contact sport. For purposes of this part, contact sports include boxing, wrestling, rugby, ice hockey, football, basketball, and sports, the purpose or major activity of which involves bodily contact. Now, we can all laugh at this rule, and it's certainly a sign of the times because looking at the list, all of those sports are sports that women actually participate in now. And most of the sports that are offered in college, in fact, really are contact sports, even those that aren't touted as such. And lacrosse being one of them is a sport I played, 100% contact sport for women, just as much as men, just with different rules. But this was designed as a protective rule for women. And again, going back to some of the things that were said about women at the time, women were not viewed as strong or particularly athletic, and so, we need to help them along, basically, is what this was. But the next and most important part of the athletics section pertains to equal opportunity, and what it says is that a recipient which operates or sponsors interscholastic, intercollegiate, club, or intramural activities shall provide equal athletic opportunity for members of both sexes. In determining whether equal opportunities are available, the director will consider, among other factors, 1, whether the selection of sports and levels of competition effectively accommodate the interests and abilities of members of both sexes. 2, the provision of equipment and supplies. 3, scheduling of games and practice time. 4, travel and per diem allowance. 5, opportunity to receive coaching and academic tutoring. 6, assignment of compensation of coaches and tutors. 7, provision of locker rooms, practice and competitive facilities. 8, provision of medical and training facilities and services. 9, provision of housing and dining facilities and services. 10, publicity. Now, I just want to take a moment and highlight the fact that these factors indicate the intent behind Title IX and is far broader than simply the team counts and the head counts on teams and how many scholarships are offered to men and women. It goes into publicity, equipment, all these things that frankly are not enforced now. But I want to highlight that because we're going to talk about that more in detail in a second. But this goes on to say, unequal aggregate expenditures for members of each sex or unequal expenditures for male and female teams if a recipient operates or sponsors as separate teams will not constitute non-compliance with this section. In case it wasn't emphasized enough, expenditures do not have to be equal. That means spending on male and female athletes in between sports does not have to be the same. So that is not a consideration that schools need to take when they are determining whether they can afford to keep a team or not. You'll notice that this is completely vague. And so to provide some clarity, we got a policy interpretation in 1979 that came out with a three-prong test that did very little to really clarify much, but it at least provided a way for schools to sort of measure whether they were in compliance. But the problem is that there's still been no real definition provided about what equal opportunity actually means. So here's what the three-prong test says. An institution is in compliance with the three-prong test if it meets any one of the following parts of the test. Prong 1 is the number of male and female athletes is substantially proportionate to their respective enrollments. And what that means is that if 1 in 10 men at the school are given an opportunity, then 1 in 10 women must also be given an opportunity. Now, the Office for Civil Rights has never provided clarity on what substantial proportionality is. There's no definition. We just know that there's some sort of a range, and it doesn't have to be exactly equal. We do know, based on case law, that 10.5% is too much, but 1.7% in terms of the gap between men and women is acceptable, and a school will be in compliance if there's that much of a gap. Prong 2 is that the institution has a history and continuing practice of expanding participation opportunities responsive to the developing interests and abilities of the underrepresented sex. So really, again, this was targeted at female athletes, and a recent study by Champion Women indicated that no schools are in compliance under this prong. And another thing about this prong is that it was never intended to be something that schools could rely on, for all of eternity. It really was intended to allow schools to not be in violation of Title IX while they tried to get in compliance, which was supposed to happen by 1978. So prong 3, the institution is fully and effectively accommodating the interests and abilities of the underrepresented sex. Now, this prong is also a sign of the times, because really at the time they felt like women just aren't going to be interested in sports. Of course, fast forward to 2020, and what we have found is that something like 50% of women in high school participate in sports. By the time you get to college, they're far less than that participating in college sports. And so for a school to rely on this now would be pretty disingenuous. And again, no schools are in compliance with Title IX because of this. So once again, there's a gigantic loophole that schools can dive into to avoid actually spending the same amount of money on female athletes, or to even really genuinely provide substantially proportionate opportunities. And that's not even factoring in the publicity and the equipment and the travel and all the things that are supposed to be factored in when it comes to Title IX, but that throughout history, courts have just punted on those issues. And I am going to do another video that goes into court cases, but for purposes of keeping this video short, I'm going to limit it. But courts, every time that there's been an issue kind of about what marketing is acceptable and what publicity is in compliance with Title IX, they basically say it's too difficult for them to figure out. So what we're left with is to look at what's going on. Recently, there was a study done by Champion Women, founded by Nancy Hogshead Maker, and what it found was that 90% of schools are not in compliance with Title IX. Let me say that again, 90%. That means 10% of schools are in compliance. And there's a whole spreadsheet that I'm going to link to that they put together that indicates which schools those are and why, and there are all sorts of statistics. But it's a pretty glaring number, and in line with, I think, what most people perceive when they experience college athletics, especially female athletes who day to day see the difference between services provided to male athletes, the equipment, the travel, the everything. There is dramatically more spending on male athletes compared to female athletes, and this study found that colleges and universities are spending $972,988,046 more every year for scholarships for men compared to women. I just want that to sit, because schools acting like they provide the same opportunities for women is nonsense when you look at that. That's almost $1 billion more spent on scholarships alone for men. And we're not talking about recruitment and media opportunities and travel and all the other things that come along with being a male athlete in most cases compared to women. The other thing that they found was that in recruitment funds, there was $162,572,192 more spent on male versus female athletes. And this is, again, this is the numbers that they were able to get. And in overall opportunities, you ask? There were male athletes were provided 183,130 more opportunities than women. So, given that Title IX has not actually created equality between the sexes or substantial proportionality in opportunities and spending in anything, do we really think that sports are cut because of Title IX? I sure don't. It's just not true. It's a cop-out, and it's a testament to the fact that they just don't value women's sports and certain non-revenue sports the same way as they do football and basketball. And that shows where the priority of schools is. Because if it was anywhere else, schools can figure out how to afford sports. Plenty of schools that don't have the top-tier Division I programs are able to run athletics programs. Division III somehow functions. And that's because of the way that they budget. Because the truth is that if schools valued the athletes at all, and this is not just women, obviously men's sports are cut too, then they would figure out how to rebudget. They would figure out how to make things work. There wouldn't be this discussion about, well, unfortunately we have to have these female sports, and so sorry, men's swimming and diving. That's not what happens. It's, oh, we wanted to keep this coach on because we feel like he wins championships, and because really what we value is making money. It's not even the athletes in these other sports. It's that we feel like they can generate more money, and we're not willing to invest time and effort into creating other sources of revenue or just managing our budget. So I'm going to leave this here. Obviously, this is a topic that is near and dear to my heart, and it's a very important one, especially now with what's going on within athletics and, cuts that are being made based on the virus and all sorts of things. And so we will definitely address that in other videos, but I would love to hear your comments. If you feel like commenting below, feel free to like, share, subscribe to this channel, and we'll see you back for another episode. All right, bye.
This video may constitute attorney advertising. The ideas expressed in this video by Maddie, as well as any posted comments, are opinions intended for informational and entertainment purposes only and should not be taken as legal advice. Receipt of this information, or using the YouTube platform or other social media platforms to contact the White Channel, does not create an attorney-client relationship.